Hello, welcome to my channel, and in today's video we shall be looking at sources of law in Uganda. First, to begin with, is the Constitution of the Republic of Uganda. This is a single document that defines the composition and powers of different organs of the state and their relationship with each other and the state. It is the supreme law of the land, and this is referred to as constitutional supremacy. This means that if any other law conflicts with the Constitution prevails, and other laws will be void to the extent of their contradiction with the Constitution. Uganda has had 3 constitutions. The first was enacted in 1962 and another one in 1967, which replaced the former one. Today, the 1995 Constitution enacted in 1995 is the current constitution of the country, and it replaced all the past constitutions. The Constitution is amended by Acts of Parliament, e.g. the Constitution Amendment Act of 2000. Then we have legislation. These are laws that are enacted or written laws made by Parliament, and they are called legislation because they are made by the legislature, which is the law-making body in Uganda. There is direct or principal legislation or delegated legislation. So we have direct and indirect legislation. To begin with, direct legislation. This is where laws are discussed and passed by the Parliament itself. For example, the Land Act and the Local Government Act were all passed by the Parliament. Laws made by Parliament are called Acts of Parliament. Then we have indirect legislation. This comes about when the rules or laws have been enacted by other bodies rather than Parliament, as a result of powers conferred on such bodies or authorities by a parent act of legislation. For example, the Local Government Act gives powers upon the local authorities to make bylaws. Examples of indirect legislation include statutory instruments, declarations, bylaws, rules, orders, and regulations, among others. If such laws are properly made in accordance with the statutes under which they are made, such indirect legislation is as binding as direct legislation. Then we have common law and equity. Common law refers to law other than legislation. It is the part of the English law that is derived from custom and judicial precedent rather than statutes. It was developed and administered by the judges of the common law courts in England. Common law is basically unwritten and is enforceable in Uganda, where there is no law to address a given matter before the court for as long as the circumstances of a particular case allow. Equity, on the other hand, is the application of principles of natural justice and fairness in the determination of right and wrong. Principles of equity are not separate from common law, but they actually developed from common law. Equity supplements or modifies common law. It developed to modulate and reform the harshness of common law by providing equitable remedies or fairness. When common law was harsh in the early years, equity came in to provide fairness and reduce such harshness. Equity is based on a number of maxims, e.g. he who comes to equity must do so with clean hands. For example, one cannot seek fairness unless he acts fairly. In Uganda, common law is only applicable where the written law does not apply, and is only applicable if the circumstances of the case allow. Then we go to customary law. This is the law that governs the behavior and conduct of people of a given community. It develops through customs and the use of customs for a long period of time. It is applicable in Uganda where there is no written law to apply to a matter before the court. It cannot apply if it contradicts any written law or is contrary to natural justice and morality. Customary law is unwritten, but it is known in communities where it applies. For example, circumcision of females was a custom in some African cultures, but is becoming eroded because it is contrary to today's morals and is therefore being challenged by various bodies and people themselves on whom it applies. Then we go to case law or judicial precedent. This is judge-made law or law established by the outcome of former cases. This is where decisions of higher courts must be followed by lower courts when handling a similar case as that which was handled by a higher court. This is what is referred to as the doctrine of precedent. This doctrine is therefore to the effect that where a lower court is faced with a case with similar facts and similar issues as a case that was earlier on handled by a higher court, then the lower court is bound to follow the decision of the higher court in making its decisions. However, it should be noted that it is not the whole judgment that forms a binding precedent. It's only that part of the judgment which contains the reasoning as to why the judge decided the way he did. Thanks for watching. Please subscribe, like, and share with your friends. Thank you.